Hi, good afternoon, everybody. Thank you so much for joining us here today. I'm here with attorney Julisse Jimenez.
Hi, good afternoon, everybody.
And my name is Romy. I'm an attorney as well, and we both work at Jurado & Associates. Today's class, we are going to be sharing it on Instagram Live as well, so we can take some questions and hopefully answer everything that we can. In our firm, we practice different areas of law. We practice immigration, litigation, probate, estate planning, business law, real estate. And one of the main people or groups of people that we deal with are realtors, right? Yes. So we have a lot of realtor friends, and we see it from different perspectives. We see it from the let's do the closing perspective to wait, we have a foreigner, they cannot get their 15% FIRPTA perspective, or the deal went south, everybody wants to sue each other, what do we do? So we see it, it's like a whole circle, right, Julisse? We see it from the real estate side, so
from the probate side,
from the probate side. Oh my God, the seller passed away, we need to do the closing, what do we do? So we like to do this class, which is the Realtor Q&A, to kind of try to answer any questions that we can answer regarding real estate law, probate, and everything as it involves realtors. I hope to make this class extremely interactive. Julisse and I are going to be answering your questions. Today's class is in English, but if you have any Spanish questions, we could also answer those as well. Just email us, contact us. Our website is juradolawfirm.com. Our phone number is 305-921-0976, and you can find us in social media all over the place. So let's start taking in questions. Julisse, share with us, I guess, your top question that you get asked the most by our realtor friends, and let's discuss a little bit so we can make this more like a conversation.
Okay, I guess the number one question that I always get asked is what happens if my client cannot get the financing? What happens to the money, and who has rights to the money, and what's the process?
Okay.
So the most important thing is to remember that everything is ruled by the contract that the parties sign.
So if you signed it, you're bound by
You're bound by whatever the contract says. Most realtors, and that's what we recommend, use the as-is contract that is approved by both the Florida Association of Realtors and the Florida Bar. And why we recommend that? Because everything is spelled out there. You know, the Florida Bar has taken a look at it, so they have things that are more or less fair to both parties. Okay, so with regards to the financing, there are several clauses that are very important, which is the financing clause.
Right.
But within that, there are several things that go on. One that happens a lot is, oh, my client didn't get the financing and the seller doesn't want to return the deposit. Now,
yes, what do I see it a lot.
So what happens is that it depends, right? The answer is it depends. It's not black and white. What does it depend on? Well, the contract says that you have to, apply for financing within a certain period.
Did they apply within that period? If you're outside of the financial contingency, then chances are you're out of luck. However, everything is negotiable. We've had situations where the person didn't apply for the financing on time. They were outside the financing contingency period, and we were still able to get some money back because at the end of the day, it goes to litigation. Litigation is extremely expensive.
At the end of the day, sometimes it's cheaper to make a deal and get some money or lose some money than go through litigation and have unknown
and go through the headache. Exactly. Yeah. So we see it a lot. So realtors, tip out there, so important. Calendar the expiration of the contingency period, the financial contingency period.
And when they have to apply.
And when they have to apply, also when they have to put in the second deposit, the first deposit, all of those things. Now, if you're faced with a situation where your financial contingency period expires tomorrow, and you don't know if your client is going to go forward or not because they're waiting for whatever else, you need to protect yourself because your client is going to come after you and say you didn't inform them. So you send them an email that says your financial contingency expires tomorrow. You have two options. One, you proceed and then you waive your financial contingency period. So that means if the deal doesn't go through, you lose your deposit. Or two, we cancel tomorrow. This is assuming the seller already did not agree to give you an extension. Obviously, if the seller agrees to give you a financial contingency period extension, take it. But if they don't wait for the last minute and pray that something will happen. Be proactive as a realtor because they will come after you, and put the buyer on the driver's seat. Have them make the decision. Listen, Your period expires tomorrow. Two options. Either you extend and waive the contingency period. So if you don't get the financing, you lose your deposit. Or two, you simply withdraw from the deal.
One mistake that I see a lot that realtors make is that they just send an extension and just leave it right there. Just because you send a request for an extension doesn't mean that they have to.
Doesn't mean anything.
Or that it's waiving the financial contingency, or if it's allowing for more time. Nothing. It does nothing. So, you know, if you cannot get a hold of the other side of the seller to get an extension signed, then if you want to protect the buyer, send a cancellation. You can always restart.
But put the buyer on the driver's seat. Do not make this decision for them, because now if you send a cancellation without the buyer agreeing to, they're going to say you basically interfered with their business relationship and sue you for that as well, because they made the decision to cancel. So don't do that. Have the buyer make a decision. And if they tell you, I want to understand my pros and cons, what are my legal exposure here, have them speak to an attorney, because that's not your job. Your job is to find the property, you did, to help them through the process, you are. But if they want to understand the risk and liabilities involved in making whichever decision, they need to speak to an attorney. So yes, financial contingency period, very, very important. Some other things that we see a lot is, of course, we're in Miami, we're full of foreigners. We love foreigners. Julisse and I are foreigners ourselves. I'm Peruvian, she's from Venezuela. And a lot of times foreigners are hit with a big news at the closing table that they need to send 15% of their proceeds to the IRS. So they come to me sometimes, like at the very end, when they receive the HUD, the closing statement that says 15% goes to the IRS, and it's not even of their earnings or what they made on the deal. No, it's 15% of everything. This is called FIRPTA. And FIRPTA, it's not a tax, it's a withholding. Way, you know, in the good old days, I don't know, 2008, maybe before that, foreigners could come buy US property, have the property appreciate, sell it, and not have to pay $1 tax. They would just go, let me take my money, bye-bye. The IRS said, no, we don't want this to happen anymore. So now we're going to create this withholding requirement, which is called FIRPTA. And we're going to make the buyer responsible, not the seller, because the seller can just go bye-bye. So we're going to make the buyer responsible, and we're going to make the title company, also the closing agent, closing attorney, responsible to withhold this 15%. So to give you an example of how this applies more or less, if you're not familiar, let's say that foreigner bought a property for $100,000 5 years ago. Well, that property appreciated in value. Sorry? Oh, okay. 5 years ago, the property appreciated in value, because everything does here in Miami, thank God. And now the property is $500,000. Well, now this foreigner needs to send 15% of $500,000 to the IRS. Otherwise, the buyer is going to be legally responsible. So the title company, this is what they're going to do. But then the foreigner tells me, hey, Romy, yes, I bought it for $100,000. I improved it. I invested $300,000. And that's why now I'm able to sell it for $500,000. So in reality, I'm only earning $100,000. Why do I need to send 15% of $500,000? Well, there's something that we can do, which is called a withholding certificate. Well, we tell the IRS exactly that. Our client bought it for this amount, we're selling it for this amount, but they invested this other amount. Therefore, their tax liability should be reduced. And then we can deal with that so that the foreigner is not sending the whole 15%. Even better is to plan it before, where you could actually, you know, create different structures so that when they're buying property, so they're not buying it in their name.
So basically the exceptions. And the exceptions are, I mean, the property is less than 300,000.
And the person that's buying it, it's going to live there and buy it in their personal name. If the property is less than 300,000 and the person that's buying it is buying it under an LLC, that exemption will not apply.
That's one of them. And then the other one is if the property is owned by an LLC.
An LLC that has two members and has an EIN, right, or that is taxed as a corporation.
Not as an LLC,
not as a disregarded entity. So, but then again, we have clients that want to get creative and they're like, well, Romy, I formed my LLC, you know, 3 years ago, and please tell them not to withhold FIRPTA for me, but then they don't have an EIN. They've never filed for the taxes of the LLC. So now the withholding will apply. And they're really strict, the title companies, because they're going to be held responsible for this. Other things that we can do to kind of not deal with the withholding is we can do a 1031 exchange. It's a little more complicated when you're doing it for foreigners, but it can still be done. So the advice when it comes to FIRPTA is if you're listing any property, find out if the seller is a foreigner. even don't assume that because that they have a social security number, they're not a foreigner. They may still be a foreigner, okay? Because there are people here on student visas. There are people here that their status may have expired. There's many situations where people are still going to be considered foreigners. Also, don't assume because the property is in an LLC that yes, no FIRPTA. It's not always the case. We have to really look at it. So that is when it comes to FIRPTA, better to plan, to do little structures here and there to avoid it.
Actually, your clients will love you if when they purchase a property and they're foreigners, you know, most people here buying in Florida, especially now, are foreigners. If you tell them, listen, you should speak to an attorney that can help you set up the right structure. So when you sell, you know, FIRPTA is not going to be withheld from you. And then the second thing is so they can plan. So if anything happens to them personally, they don't have to pay a huge estate tax as a foreigner as well. So that's something else that they can do at the beginning. So absolutely. If you give them that advice, because otherwise, if you have a foreigner that passes away and they're going to have to pay 40% of the value of that property.
Oh, that's another thing that we see a lot through the probate part of our firm when it comes to foreigners buying real estate. So we do probate all over the state of Florida. And if a foreigner has never set foot in the United States, or even if they have, as long as they have Florida property in their name, that property is going to have to go through Florida probate. No other judge anywhere in the world has jurisdiction over that property. It's going to have to go through Florida probate. So a lot of times the family finds out that the property was really titled under the mom or the dad. The probate started in Argentina, Peru, whatever it is. And then here they thought that with the order of their country, they can simply use that at closing and sell the property. That's not the case. So we're able to conduct probates really fast, depending on the nature of it. If it's just one property, we're able to do certain things to not to delay the closing, but it's always good to let us know if it becomes litigated, because then, you know, somebody pops up, does the son, somebody pops up, does the lover, then that might delay things, but usually that's not the case. But let us know, of course. Foreigners are subject to a 40% state tax. It's crazy, I know. We all are subject to a 40% state tax, by the way. Me, you, Julisse, everybody. However, we have an exemption of up to 11 million, I think, nowadays. So unless you're super rich, which I hope you all are, you're not going to be faced with that 40% state tax for now. But foreigners only have a $60,000 exemption. So let me explain to you more or less how that works. Let's say that the property, when the person passes, the foreigner, it's worth $1 million, okay? So the property is worth $1 million. So out of the million, they're gonna take 60,000, all right? So now your state, as a foreigner that's subject to the 40% state tax, it's 940,000. So 940,000, it's gonna be subject to a 40% state tax. That's a lot of money. And what can you do at that time? Pay it. Unless there is some treaty, which very seldom is the case, at that moment, you just have to pay it. However, there's other situations when you plan before, for example, if you decide that this is something that you don't want your family facing, you can do different structures. We may be able to create a company abroad and then one here. And then when somebody dies, nothing really happens because both companies are still existing. That's one option. Some of my clients are like, I don't want to deal with companies anywhere. What else can I do? You may be able to buy life insurance and then have the life insurance be paid out to your beneficiaries. That's another thing that you can do.
Pay for the 40%.
To pay for the 40% state tax if you don't want to create other companies. What else can we do?
Well, another important thing that I think we have seen is if you have a listing and you know the seller, this has just happened in one of our closings, you know the seller, one of them passed away, even though the property may have been transferred by the county appraiser to the surviving spouse, that doesn't mean that the property is free and clear from a lot of requirements, you know, for the closing. And one of the things that, you know, that they may require is a closing letter from the state, from the IRS. So when you list the property, ask them, say, is the state finished? What's going on? You know what? Because you may get a full price offer, you may sell the property, and you may not be able to transfer title if you don't have that closing letter from the IRS, because it's going to be a title requirement. So it's good that you find out who your seller is and what they have. If somebody has passed, even if the other spouse, you know, is surviving, and especially if they're foreigners.
Right,
Going
especially
back
if
to
they're
that,
foreigners.
because they're gonna owe money on that, maybe, unless there's a treaty that we were talking about.
Right, maybe, but that's very seldom the case. When you're listing property and you found like a house that's, really run down and you're like, well, this might be a probate property, what can I do? It's so important that you find out who the right person is to list the property. Is it a personal representative because that state has already been started? Or do you have to go around chasing the heirs to see that they have the right to list the property? Otherwise, if you just have anybody sign you a listing agreement, you list the property, you won't be able to close if they didn't have authority to sell the property. So if it's a trustee, for example, you need to, if it's a trust, the property is owned under a trust, you need to make sure that the trustee is the one that's signing. So you always want to make sure whenever listing any property, you want to make sure to confirm who has title to the property and who has the legal authority to list it. This is something that we can help you as well. Divorces, we don't do divorce law, we refer them out because they're a sad law. I don't particularly like it. However, we see it in our practice because there are situations where a property is listed and they're about to close and then they're going through divorce. So now the wife is like, I never signed a listing agreement. I don't have to agree to sell. And the husband's like, wait, what? We were all in agreement that we were going to sell. So I only signed it. Guess what? That's going to be a litigated issue because most of the time in Florida, husband and wife own property as tenancy by the entireties. What that means is that they each own an indivisible interest, 100% of the property at the same time. So I need to make decisions over my property and so does my husband. Whenever listing property that's owned by husband and wife, please get both the husband and the wife to sign the listing agreement if you want to have an enforceable contract. Because otherwise, this can happen.
Starting with an enforceable listing agreement.
It's starting with an enforceable listing agreement.
You may sell it, you may get to have a buyer, you may have everything, and you're closing, and you're like, seller, too bad, so sad. You're gonna have to pay my commission, and the other seller's gonna say,
yes, that happens too.
I didn't sign the agreement, so I don't have to pay you anything.
So you want to be
order to list.
Exactly. So you want to be really careful with that. What else? Let's see. I want you guys to ask us any questions that you have. So please.
There was a question.
No, I didn't see it, but let's talk about commissions and when the deals go south. So the buyer doesn't want to buy anymore, right? They change their mind and the seller is like, hey, listen, I want you to buy. So we have in Florida, we're able to do, well, we can't force the buyer to buy, no, but we could go after the deposit. And the realtors, the brokers, if you procure the buyer and you did your job, then you could also come after the deposit as well.
Well, actually, the listing agent
can
go after the deposit. The buyer's agent cannot. The buyer's agent can then
come after the listing agent for the deposit.
Or the MLS, basically.
Exactly.
That's kind of like the contract, that's like your MLS.
So you want to make sure that you address that. Now, let's say the seller is the one that changed their mind, and this happens a lot too. In Florida, we're able to sue the seller to force the sale. So that is something that we're able to do in Florida.
Performance. Only if the buyer was ready, willing, and able to buy. What does that mean? Well, is the buyer buying cash? Does he have the money to close? If the buyer's getting financing, the buyer has to show that they had the financing in place to be able to close, especially if they're like 95% financing, 80, 90%.
You have to show that you were going to get the finance.
Yes.
Had everything gone through, you were going to get the finance. So,
exactly.
And then you can sue for that. So we've done that as well. A lot of times what ends up happening is people come to an agreement. Like in anything in litigation, people come to an agreement.
Because it's expensive to litigate.
It is.
So if there's $20,000 in escrow for the deposit, that very quickly is going to get eaten up by attorney's fees.
Right.
That's what happens.
So what else do we see? Let's see. When things go south and realtors are not protected. There's so many things, but I'm trying to think of copyright violations. All right. Stop using other people's images. If you didn't take the picture, it's not yours. If you didn't get a license for it, literally a contract that says I'm licensing you the rights to use my pictures, it's not yours. And you can get sued for that. And we have seen it. There's something called a DMCA notice where if I see somebody violating my copyright, I can notify the internet service provider, I can notify Instagram, and they will take your account down. So please don't do that. If it's not yours, you didn't take the picture with your little hands, don't use it. Or if you could also buy the licensing, and make sure if you're buying licensing that you're buying it for commercial use, because that's different too. There's some licenses that you buy from images online that's only for your use, personal use, non-commercial. And then there is the ones that you buy for commercial use, which may cost a little more. But copyright violations, we do see a lot, and there's really not much of a defense. There's no defense, and they don't have to notify you before. If you violate a copyright law, they can come after you.
I was just thinking about something right now that I've seen it happen, because there's so many people that want to buy properties. Realtors sometimes take several offers, and they have the seller sign all offers. You got to make sure that the offers that are signed as secondary are signed as a backup contract.
Correct.
Because otherwise you're submitting the parties to being liable to 2, 3, 4, 5 different contracts. There can only be one contract at a time to sell the property. There's only one property to sell. So it has to be noted as a backup contract. The other person has to know that that's a backup contract. If it wouldn't come
Written
into
all
effect,
over the place, because otherwise you're going to get into hot water
until the other one doesn't go through.
Also, realtors, if you're an agent, okay, and you're doing other stuff on the side, for example, you're helping people buy foreclosure property, you're helping people buy property in the tax deed sale, whatever it is that you're doing that's related to real estate, but you're not acting as a realtor, please make sure you have a contract that clearly lays that out. Otherwise, they're going to hold you responsible to a higher standard. They're going to file a violation in FREC, and you're going to be held responsible as a realtor, because you're supposed to know, and they're going to claim that you were acting in your realtor capacity. So please be careful when you do stuff like that. You're doing flips, you're doing stuff for people that deal with real estate, but you're not acting as an agent. You have to have an independent contractor agreement that lays out exactly what you're doing, how are you compensated, what are your responsibilities, and what are their responsibilities. And you clearly disclaim in there that you're not acting as their agent. We see this a lot as well. So easy when a deal goes south, and they didn't like the remodulation you did, whatever it is, they're going to go file against your license with FREC, and you're going to be in problems. So just make sure that that's clearly laid out. What else?
Buying property with foreclosure, and they don't know that there's another mortgage on it, or
Yes, if you're helping people, I don't know, you register with the county and you're helping people buy foreclosure property and you're facilitating that, it has to be so clear that you're not making any representations regarding
title,
marketability or title or issues. Because yes, you can buy a foreclosure property, but that doesn't eliminate all the liens and everything that's there. It does not. And then the buyer is going to come after you and sue you, and it's going to be a big mess. They may or may not win, but to fight it, to litigate it, it's going to cost a lot of money. So make sure you have a contract if you're doing that.
Yeah, no representation as to title.
We do quiet title actions. A lot of our clients are buying tax properties, tax deed sales and things like that. And we do a lot of quiet title. And sometimes it could be inexpensive because nobody's fighting it and things like that. Sometimes it could become really expensive because people are fighting it and they're saying, no, I didn't acquire it this way. There wasn't proper notice. So if you're helping people with that too, just keep that in mind. You can never assure them it's going to be, don't worry about it. You just need to do a quiet title and you're going to be good to go. You can't do that because we don't know what can happen. A lot of things that we're seeing too lately is foreigners buy property under an LLC, or even people buy property under an LLC. They forget about it. They think, okay, I formed a company, I bought the property, bye. And little do they know that title was changed. We just had a case. It was a big case, and sadly, sometimes you can help, sometimes it's a little too late, especially if you didn't do much about it at the beginning. So
yeah.
For those of you that are thinking about, telling your clients, buy properties, this and that, just also put it in writing there, hey, or if they're doing it with an attorney, it shouldn't be an issue. But if you're the one, because I know a lot of realtors there are trying to make money and doing their LLCs here and there for their clients, please be careful that they know that this is not a one-time done deal. They need to renew every year. They need to keep up, because it's so easy for somebody to go into the Florida Secretary of State and just change the information, sadly. So, and we do see that a lot. What else do we see that our realtor friends are facing?
With regards to the LLCs, also you have to be careful that if you're forming LLCs and doing things like that for your clients, that you're not crossing the line of practicing law without a license. So don't give legal opinions about things, because they get into a lot of trouble from those issues.
Yeah, don't give any legal opinions. Tell them to consult a lawyer, to consult an accountant, because look, your job is to find the property and sell it, but they're going to hold you responsible. And I'm telling you this because we see it in our practice. Who's the first person that they throw under the bus? The realtor. So please don't buy yourself extra liability. People need to be, I understand they have questions. They need to seek the right professionals. What else do we see? Trademarks. It's so important to protect your intellectual property. For those of you agents that are working under a group and you have this catchy name, you can license that. You cannot create a company and work under that name because the Florida Association of Realtors doesn't allow it. But if you're marketing yourself under a special name of a group and you don't want other people to use it, you can trademark that. You can trademark a logo, you can trademark your name, your slogan, your group name, whatever you're using. And what trademark allows you to do, it's a federal protection that allows you to stop others from using it. So if your trademark is the best realtor of Miami, something, something, and somebody else wants to use that, now you can send them a cease and desist letter telling them to stop the usage. Otherwise, you can sue them, recover damages, and attorney's fees and costs. So it's really fabulous. Trademark is there to protect you. This applies to anybody that's doing business. One of the most, if not the most important asset that you have, is your intellectual property, your brand. We're all about branding nowadays. Well, you may have the domain, you may have the company, you may have even a DBA, you can have all of the Instagram handles that you want. But if you don't have a trademark, you have nothing. And if somebody registers a trademark with all those things for the service or products that you're selling, they can stop you from using it. So if you get anything from this Q&A, is protect your intellectual property, regardless of the business that you're on. It is extremely important to protect your intellectual property assets.
Another thing that's very useful for realtors that we do in our practice is partition actions.
Oh, yes.
Because, a lot of times, people that own property together are like, yeah, I want to sell, but my other, the other owner doesn't want me to sell, and I've been paying all the property taxes and the maintenance and the insurance and this and that, and they don't want to sell, and they don't want to sell. Well, there's an action that we can do that is co-partition. So we ask the court to basically, if the property were to be divisible, to divide it, in equal parts, whatever parts. Most of the times it's not, especially condos, houses, things like that. So basically what they will divide is the share of ownership. So let's say that, I own 20% and Romy owns 80%, then basically we'll ask the court to do something like that. But then I say, okay, but Romy, but I paid 50% of the expenses, so why should you get 80% when I paid 50? And that's where the litigation starts. But that's something that you can tell, you can help your client say, hey, if you want to sell this, you can do this first. And then within that, we find a buyer and we ask the court to approve the contract and get it all done and distribute the proceeds.
Right. This happens a lot. Friends buying property, partners buying property,
even
married people buying property. And then they're like, well, I don't want to share this property with you anymore. But then the other one doesn't want to sell. So you have to force a sale. You do a partition action. And you could ask the court to pay you for everything that you contributed to the property, because maybe only one person was paying the maintenance, everything else. So we do that. It's a process. It's not easy. It's not fast, but it can be done. You don't have to be with that person forever if you don't want to continue owning the property.
And you can kind of divide it, because I know that, the realtors want to, sell the property and get the property, get the contract done and get all that done. So part of it can be, okay, the court orders the sale because the parties, let's say, agree to the price or, something. And then you can say, okay, court, order the sale, and then later on we'll let you know how to distribute the money.
Exactly. So
at least that helps it, especially now. If you can sell for a really high price, you don't want to wait.
You don't want to wait. So we can do that. We can help you with partition actions. So we mentioned partition actions. We do those a lot. Quiet title to clear title. We can do that as well. You have probate. Somebody, sadly, people pass away, or the heirs, they need to sell. We can do all of that all over the state of Florida. Immigration is federal law.
In a way.
Oh, well, they should be doing estate planning, absolutely.
Even if it's just for the holding of the property, but
Yeah, so we do estate planning, especially for the foreigners, that they need to make sure that the property is titled however they want to title, and it goes to the people that they want it to go to. We also deal with immigration, and we're able to help with E2, EB5s, and L1s. There might be a big change with EB5 next week, or maybe even this week, where the regional centers might be reauthorized. Everybody's hoping for that. and they're going to increase the investment amount probably to $800,000. But the EB-5 is a fabulous visa because it's residency. It allows foreigners through investment in a regional center to create certain number of jobs that the regional center will help create through the projects and obtain residency for themselves, their spouse, and their children under 21, assuming they have the money and they can prove where they got the money, because it cannot be money they got from extortions or anything criminal. So we will help you with that to show the proof of funds. There might be a big announcement about that next week where they will reauthorize it, so we can help with that. We also do E2s, and E2s, these are investment visas, and they work really well with real estate. We've obtained investment visas for people that come and buy a shopping center, or they buy various properties that they manage, or they are doing the flipping business, or they buy a bunch of multi-housing, and whatever it is, dealing with real estate, we're able to do E2s. So we can help with that as well.
Evictions.
Oh, evictions. Yes, yes,
That's
yes.
a hot topic.
Hot topic right now, because as you know, all the moratoriums are gone. However, there's still little things in there that the courts haven't fully, I guess, caught up with certain things that are no longer protections that are there. So we're dealing with that right now. We do both residential and commercial evictions all over the state of Florida. And we try to do them as fast as possible, but sometimes it's out of our hands. It's up to the court, and if there's issues or if the person fights it. However, if they fail to pay rent and you want to evict them for possession, not to get the rent paid, but for possession, you serve them, they have 5 days basically to answer. So there's certain ways to do things a little faster if you're only suing for possession, not for money. Now, why wouldn't you sue for money? Because they don't have money. That's why they're not paying rent.
Or because you can't get a hold of them.
Right, that's the other one, but they just disappeared on you.
Because they may still have the key to the let's say it's a condo, they still have the key to the property.
And you can't change the locks. You cannot.
Their personal property inside, or they tell you can't go inside, but you can't find them to give them the summons for the personal service.
Exactly. So then we would have to do an eviction and then
try to find them.
And then
that's the problem. That's the only issue with with evictions. If you know that somebody works for a well-known company and they have money and they're just basically not paying the rent, like a lot of people were not during the pandemic, then yes, sue them also for the money. But otherwise, it's really sometimes not worth it. You're gonna spend money and you're not gonna recover anything.
So I have people asking us if we can speak as to what is quiet title and when it would come into place. So tell us about quiet title, Julisse.
Okay, so a quiet title is basically when you have something is on title that you're going to try to get off the title. Not that there's a mortgage, that you got a mortgage to your property and you sign the documents and all of that is, you can't get that off the title. But let's say that somebody else put a mortgage there that doesn't belong to you, okay? You would do a quiet title and you basically sue the bank and say, hey, you're damaging my title. You need to get off it, and a court will determine that. So when you buy also, let's say on tax deeds and things like that, they're going to be people that, you have to basically kind of close the right to the property, in legal terms, and basically get them off your title. Because when you sell it, you want to make sure that all your conditions are clear, that, because otherwise you would have to do all of that. It would be a requirement for you to sell it, to get rid of some people that were there before, because since it was sold on a tax deed, it wasn't properly legally closed those rights.
Right. So especially in a tax deed, you have to do quiet title in order to be able to sell that property. Because when you buy a property in a tax deed, it's because somebody failed to pay their tax. The court will give you a deed, but there is no title insurance. So then you have to do a quiet title, sue anybody that could potentially have an interest in the property. And now, once we get that, we are able to issue title insurance. So that's when quiet title also comes into play.
Also, when you buy a foreclosure property, sometimes they're, wild deeds, and they transfer the property from the company to individual, to another individual, to another individual, to another individual. Maybe not all of them were named.
Right.
So you kind of have to go.
So that's when you do quiet title. Whenever there's issues in title that you're looking to clean, we can do a quiet title. Partition is whenever you own a property with somebody else and you want to sell off that property. So then the court forces the sale. Those are the actions that we see a lot of. If there is a forged deed, like if somebody, fraudulently did a deed and transfer your property, we could also void that deed and we can work on that. We've seen those a lot. Sadly, it happens here in South Florida.
There's another question that says, can we cancel an addendum made to condo docs in 2016? And can condo units be dissolved from the association? What is the procedure? Well, that's a very specific question that we would have to actually read the condo docs and see what the condo docs say and how, that is done. And, that's not something
that's not something we can just answer you from here, but reach out to us and then we'll be able to help you. Okay, so we have another question. It says, I know it's a bit off topic, but in regards to 1031 exchanges, does a promissory note qualify for 1031? Just recently had a buyer that had one and was under the assumption that they can do a 1031 exchange since it was an interest only in note. I'm not sure I understand the question, but 1031 exchange allows somebody, an investor, who owns property to sell that property, and as long as all of the money goes to what they're called qualified intermediary, meaning the investor doesn't get the money in their pockets, they're able to use that money to acquire another property, and they don't have to pay capital gains at that moment. That tax, it's going to be deferred. I'm not saying they're never going to pay it, they just don't have to pay it at that moment.
It gets suspended in time
It
until
gets,
you
it
actually
gets
realize
deferred.
the
Correct. But then what a lot of investors do is they'll do that now, and then they'll do it again and again and again, and then the tax gets deferred. And then the investor will go to heaven. And then when their heirs of the investor get it, guess what? They get it at market rate, at market price. So they don't even pay the tax that was deferred when they get it. This is what happens right now with the current law that we have. So it's a great estate planning tool to do this 1031 exchanges, because you can basically defer the tax, and then if, assuming your heirs get it and the law doesn't change, they won't have to pay the tax when they get the property upon your passing.
Now, you can't do the 1031 exchange once you sold the property. You
No.
have to do it before, and it has to stay. The money cannot touch the seller's
Right.
hand.
The money cannot touch the seller's hand nor the seller's agent. A qualified intermediary can be a person, they're usually companies that have not represented the seller, nor are there any type of agency relationship with the seller.
That's not to mean the real estate agent.
No.
You get your commission.
No.
Clarify.
And you still get your commission. But then all of the money that the seller realizes will go to the qualified intermediary, and all that money will be deposited within certain time periods. You have to identify the property within 45 days. You have to close on everything within 180 days. And there you're able to defer this gain that you would have had otherwise. So it's a great estate planning tool, 1031 exchanges.
And it has to be a like-kind exchange.
Right, so you have to, if you're selling real estate property, you have to buy real estate property. So we only deal with real estate property 1031 exchanges. If you have other questions regarding non-real estate property, then that you would have to consult an accountant. Okay, somebody's asking, that's what happened. My client sold a lot and did seller financing, but now the company is buying the lot and they're paying her for the rest of the note. That's a very specific question, but if your client didn't involve a qualified intermediary when the property was sold, there's nothing we can do at this moment now. It's so important to do it before the property is sold. The qualified intermediary needs to be engaged. Everything needs to be properly documented, because the IRS doesn't play. They're not going to help you. They want you to comply before so that you get the benefit of the tax deferral. All right, let's see if we can answer more questions. What's the one thing that you see a lot, let's say, well, we dealt with closings, but aftermath. Remember when people get angry, they want to sue the seller because they failed to disclose something, and they found a bunch of rats, or they found leaks, or they found something. So what do you think? What do we say to the clients?
Well, the most important thing is not to, if you know there's a leak or there's mold, don't put paint on it and just brush it off. It's going to come out, and then they're going to sue you for misrepresentation or for fraud, because you have to disclose anything that is not observable to the buyer.
Yeah, if you know it. And when I say you, I mean the seller or the realtor. If you know it, you have to disclose it.
And then what happens is the agent should have known. They should have found out what's going on. You can't just list the property and say, oh yeah, it looks pretty, that's it. You have to really look. You're basically the seller's agent. Whatever the seller tells you, that's what you're saying. So they're going to put you into a lawsuit because you said the same thing.
And also don't get creative and be like, no, that's not mold. That is just, it just needs a little paint or a water stain. Listen, I'm not a property inspector. I don't think you're either, nor do you want to assume that liability. So don't. If they have any questions regarding the situation of the property, they need to hire an inspector. They need to do whatever they need to do diligence-wise so that they are prepared. I don't even want to recommend inspectors, to be honest. I want the buyer to go find their own inspector because I don't want them to come say to me, oh, but you recommended the inspector and now I cannot sue the inspector because they have all these disclaimers within their inspection report.
I was just going to say the inspector has a very limited liability.
Yeah,
because it's to the amount that you paid him to do the inspection. So sometimes the realtors are like, oh, don't worry about it. You know, you can do a 4-point inspection that's, you know, it's going to cost you $200. It's cheap and they'll let you know what's going on. Well, if they didn't find something out about that property when they did the inspection, well, you know, it's like kind of too bad, so sad.
Right.
Who was they going to sue?
Nobody.
And then they're going to come after the agent.
They're going to come to the agent, yes, always. So look, sellers need to do their seller disclosure. They need to disclose what they know. If they don't know, they don't know, and they need to put that. If you know something, disclose it. You don't want to be assuming liability on behalf of the seller, and you will, because that's what's going to happen if they think you knew. So you could potentially sue somebody if you buy a property and you find a lot of problems with it for failure to disclose. If you think they actively concealed it, of course, we're talking about the assets contract, right? Because that's usually the one that is used. But it's always important to have the seller disclosure done and have the buyer reach out and be informed that they can perform any type of inspections they want to do. I have buyers that want to perform inspections of the water under the house because they want to know if the pipes are going to explode. I said, by all means, go and do that because I cannot tell you that the pipes are not going to explode. I don't even know if my pipes are going to explode or not. So it's so important. Let the buyers do whatever inspections they want to do. Encourage it in writing, whatever you do in writing, so that later they don't come and tell you otherwise. Oh yes, if you're helping people buy cash, please, 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 please send them an email. Buy property insurance. They will tell you that they don't want to pay that extra money. They're buying cash, so they're not required to have it. Okay, we've had situations where the tenant fell down, there is no property insurance, the tenant's now quadriplegic, and now they're suing, they're suing to recuperate that house, right? And then the seller, sorry, the owner of the property also had other houses with the same LLC. So now they're gonna get all of that, okay? So please, people buying cash, get property insurance. I mean, to me, it's so important.
You know, require the renters also to get insurance, but
require the renters to get insurance, absolutely, and add the landlord as an additional insured. Yes, the more insurance is not a bad word. It's a great word. It's protection. In this country, gladly, we're able to buy insurance that will answer for you. You know, it's not like you're gonna, you know, go to your policy and they're gonna say bye-bye. No,
better to have a policy that is gonna cover than to have nothing and then lose everything.
And then lose everything. And sadly, we've seen that a lot, right?
Yeah.
And they're like coming to us, and the best thing that we can tell them is settle and settle quick, because it's going to be so much money.
I know what's important right now. There's a lot of movement with properties, and there's some bad people out there, and some bad people pretend to be the owners of the property or pretend to be other realtors. And there's actually, I think there's a case right now that was on the news regarding that. So make sure whoever you're dealing with is a licensed realtor.
Yes.
If they say they're a licensed realtor,
look them up in GDPR.
And when regards to the sellers, they're leasing a house or they're selling a house, whatever, make sure they're the sellers. Look them up on the property, you know, appraisers. Check their names, Google them. Do your homework so that you don't end up being on the other side of the fraud. You know, there's a lot going on right now.
Yes,
because there's so much movement.
We've had situations where rowdy agents list like the same property twice or 3 times in the MLS, because there's ways to do that if you're rowdy. So don't do it. So you want to check. If I were in your shoes, I would call the agent, I will call the broker, I will look up their license number just to make sure I'm dealing with the right person, because you don't want to have any issues. And never, oh my God, I've seen this too. They're like, no, the seller will only sell if we give them the deposit to their name. I'm like, what? What is this? Never. Always to the law firm or to the title company. You want to make sure that it's done to the law firm, to the title company. Otherwise, you're never going to see that money again. Okay. All right. I think that concludes our webinar for today. I don't see any more questions, but if you guys do have questions, please, by all means, feel free to reach out to us. My email is romy@juradolawfirm.com. This is my Instagram, so you can WhatsApp me there too, Romy Jurado, ROMYJURADO. And then Julisse, well, I don't think we're on your Instagram,
but Julisse@juradolawfirm.com.
And then you can call us 305-921-0976. We try to be really responsive to our clients. We have a group of fabulous attorneys, paralegals, legal assistants, and we really try to go above and beyond to help all of our clients. We are experienced in different areas of law, and it's good because they all come together a lot of times, especially when helping you guys realtors, because just like you guys, we deal with people from all over the world, and we're able to assist them in different areas of law. So I hope you enjoyed our webinar. Thank you so much for attending. Thank you, Julisse.
Thank you, Romy. All right, thank you, everybody. Bye-bye.
Bye-bye.